You are wanted out of the state of Nevada, specifically Clark County, for a robbery. And you are asking me to set you a bond. Is this right? Okay. I don't know anything about you. I'm now getting to know you for the first time, so I don't know. My primary concern is, are you a dangerous person? Because, you know, I have so much drama in my life right now. It's ridiculous. I just don't need any more. And what I don't want to do is release you if you are a danger to my public, because I cherish that, right? I don't need any more. So we're going to find out a little bit about you, and then we'll see where we go from there. Amy, let's get to know Mr. Jefferson.
Yes.
Yan say judja katuna clear ujatay. Unclia saps important sol ya hai kakia is shocks KO release karna public kulia safe haga yanahi.
So he's wanted from Clark County, Nevada for conspiracy to commit robbery, and theft value over 100,000 or greater. The state's opposed to a bond at this time. He, as the court knows, he's being held. Well, he's not being held. He's made bond also on robbery threats in the 228th and reckless driving.
He has another robbery? Here?
Yes.
That's local?
Yes, it's a robbery threat in the 228th. It is open. He's made bond on that.
Okay.
So you got a robbery there. You pick up a robbery here too. It's a robbery.
This warrant was also issued December 18th, very recently.
When was bond posted, if you don't mind on that?
Yeah.
He's he's on bond. He's on bond for reckless driving.
Okay.
Picks up a robbery here in September. So I guess he's on bond for a robbery here, and now he's picked up another robbery in Nevada.
I thought the robberies in Nevada were old.
Well, she said they were just issued 12/18.
He made the bond for the robbery threats on September of this year. That case was filed also September of this year. And then this new warrant was issued this December. His reckless driving was...
What court is that out of?
That was the 28th.
No, the reckless driving.
Oh, this one's out of court 10.
What's the court date on that?
That is
January
on January 30th.
He has a general order bond on that?
Yeah, he's made bond on that one. He also has made bond on the robbery.
And he's made court, has he made, my question is, if he's made his court appearances, Your Honor, I mean, I think he's proven that he should go into court, showing up to court. So if you did consider bonds, he could then, don't worry about the reckless driving.
The state also wanted to add that he was just barely out of parole from earlier this year.
He was what?
Barely out of parole from earlier this year, as they have.
Who is he on parole for?
That I don't know exactly.
Mr. Jefferson, I gotta be frank. You scare me, man. You know, you continue to pick up cases, and they're serious cases, right? Second-degree felony. I don't know, maybe this is a third degree, but nevertheless, you have a robbery here, you pick up a robbery over there. That scares me. If I let you out, are we gonna get a third one? I don't want that to happen. I know you're telling me no, but history tells me otherwise. All the open cases tell me otherwise. Now, I do have some good news for you. The good news is that you've made bond on these two cases here, so there's no holding pattern, meaning that Nevada has 14 days to come get you, and if they don't come get you, then Harris County releases you. So you have that going for you now, you know, but I just don't feel comfortable giving you a bond. You scare me, man. The last thing I want is a third robbery.
Jab Judge Kate Hain. You scare me, man. To yes surf ek phrase nahi hoda.
EX trong signal hota hai ke cao có lắc ra ha hai ke defendant society ke lai serial risk ban sakta hai.
You understand? You gotta understand from my perspective, I don't know you. You're telling me all these gumdrops and rainbows and bunnies jumping in the woods, but you've got all these 3 open cases. They're serious. Sorry, I can't, I mean, just...
Okay, he signed on Monday, Judge, so I guess,
so
can we reset it to, what is that, the 8th?
Case, right, Monday, so 1, 2, 3 days have passed. So you got another, what, 12 days, give or take?
So can I get a reset for the 8th? Is that correct, if I'm counting it?
The 7th.
The 7th, even better, okay.
Yeah, so you said the 23rd?
He signed on Monday, the 23rd, is my understanding. So I think the 7th.
Yes, the 7th.
So if they don't come get you on the 7th, you'll be released in Harris County.
So they have until the 6th to come get you, okay? If they don't come get you by the 6th, then on the 7th, you'll be released. But you got to understand, even if we release you, that warrant will eternally remain open. And you could get picked up again the minute you walk out of custody. If you do get out, I would immediately go back to Nevada, take care of that. Otherwise, at some point, you're just going to get picked up again, and it's going to continue to happen.
You can hire an attorney.
And the other thing is that, right, when you do go up there, you got to let your attorney here know what the plans are so that you don't get revoked upstairs here, because then you're going to be in the exact same situation over there like how you are here. You understand? So if you go over there to Nevada and try to handle things and they put you in custody and no one knows about it here in Harris County, you have not advised your lawyer, they may think that you've just jumped ship and they might revoke the bond here, and then they'll place a hold here in Harris County because you're in Nevada. And if nobody knows, you know what I mean? So you got to let your lawyer know here.
You're a misdemeanor lawyer on your record. Do you have a lawyer for both of them, or were you appointed lawyer?
Not a lawyer.
Okay, so you need to tell your lawyer that if they don't pick you, you need to contact him, let him know you're in custody.
He has a lawyer in the felony, so
Yeah.
let your lawyer know in the felony
You let
case.
them know, and if they don't pick you up, you need to hire someone in Nevada, try to get you bonds on those, or you're gonna have to go out there and address them and turn yourself in and then see if they give you a bond.
All right.
So if they don't revoke your bonds here, you need to let your attorney know. You understand all that?
បនដេនីកាន់កែបាវ៉ារ៉ូតយុទ្ធកឺ defendant ក៏ detailman សាំយ៉ាតាហើយកែ Nevada កាវ៉ារ៉ាំងកៃស្ហេនដូកាណាហើយ
Ya courtroom ka human side daikata hai.
Okay, man. Good luck.
Thank you, Ron.
Thanks, Frank. Thanks, Amy.
I think that's all I have.
Good morning, Mr. Rodriguez. So you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and/or a $4,000 fine.
Judge, on December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that he followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close, and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor, the sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, on December 18th, 2024, the officer was
So same day.
Same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant, who stated that the defendant broke his window with a rock. The officer made contact with a witness who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house, and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200. Yes. Oh, okay. My apologies. I was reading because he was just picked up an assault. Let me read the assault that's out of the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. The officers detained the defendant, and a search of his person revealed 0.68 grams of meth in his right pocket, and the defendant was taken back to the original scene, and the officer spoke to the complainant, who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. A witness, the complainant's girlfriend, witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right, Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication.
Yahan allegations coffee serious hain. Physical fight, choking, or property damage. Judge KO turrent lagda haika drugs is behavior capiche hosokt hain.
If you have a problem with drugs and alcohol, you better address it, because I'm telling you now,
No, it's not a problem, sir.
look at me. If it becomes a problem, I'm going to address it for you, and I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please.
Yes. I will
Stop. Don't say anything.
consume marijuana.
Stop. I'm sending you for a drug test now. I'm gonna have you come back. I want to see what's going on. That's it.
Okay. All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test, and I want you to come back. I'm going to appoint your lawyer today.
Defendant insists karta hai ku usi drugs ka koi ishunahi. Judge bina debate ku turrent drug test order kar dita hai. Kabi kabi sach John ka sabs betterine tarika test hoda hai.
And you have those results.
Great.
Judge, David presented Faulkner for THC, amphetamine, MDMA, cocaine, and
I think that's not, I mean, really. Stop. It's a rhetorical question, Mr. Rodriguez, but I'm going to tell you now, it stops today.
Sure.
We're going to do this the easy way, or we're going to do this the hard way. I am giving you the opportunity for you to try to do this on your own. If you are incapable, then you're going to stay with me, and we will do it the hard way. Do you understand?
Yes, Your Honor.
You will be required to test bi-weekly here with me, so I know that you're not using. And if you show me that you can stay clean, then I will stop. But we will do this in baby steps. But for the time being, you're going to stay here and test a lot with me. Do you understand? I will give you a pass of 45 days on the THC, 45 to 50 days on the THC.
Sure.
But if after that time you continue to test positive for marijuana,
Yes, Your Honor.
I have given you a lawyer. It is your responsibility to stay in touch with Anna. If Anna tells me she can't get a hold of you because you play games, likewise, the bond will go bye-bye.
Yes, Your Honor.
Drug test ku results shocking hain.
Tehasche, cocaine, meth aur MDMA.
Judge ka message sita hai. It stops today. Ya punishment esi zayada ek wake up call lagda hai. Kalip bai.
All right. Okay.
Thank you, Judge. We'll see you on
All right,
Monday.
Mr. Rodriguez, see you Monday.
Yes, Your Honor.
Thank you. Can we be excused?
Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 16, 2024, officers were dispatched to a Lowe's in Harris County, Texas, in response to a theft in progress. Dispatch stated a male and female suspect had concealed items from the sales floor on the male's person, and a male threatened to hit the loss prevention officer overhead with a hammer while exiting the business. The complainant, the loss prevention officer, let the defendants exit the store and gave a description of the defendant's motor vehicle as it fled the scene. The officers made contact with the complainant, who stated he observed the defendant and the co-defendant, the male, select items off the shelf and conceal them. The defendant was using her purse to cover up items as the co-defendant concealed them on his person. The complainant confronted the defendants as they attempted to exit the business together, and the co-defendant stated he would hit the complainant with a hammer. The defendants were identified by the complainant, and the defendant's motor vehicle was searched incident to arrest, revealing several hand tools. The complainant identified items belonging to Lowe's for a total of $305.35.
All right. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go to any Lowe's. Do you understand? If you violate these conditions, your bond will be revoked, you will go into custody. No more. Do you understand? Tell me.
No more lows. Ya line 30 funny lag sakti high. Lekin judge ka message clear high. Agar bond par rena high. To trouble se door rena haga.
Everything I need to know. Do you understand? Okay. Good morning, sir. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 18th, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas, and the officer met with the defendant and complainant, who are members of the same household. The officer observed no visible injuries, and the complainant stated she had been living with the defendant for 7 months. The complainant stated they were arguing in the morning, and the defendant pulled her by her legs off the couch. The complainant stated she hit her head on the coffee table as a result of the defendant pulling her off the couch, causing her to feel pain. The defendant stated the complainant had been evicted and he let her stay with him, and the defendant stated the complainant said something disrespectful, so he pulled her off the couch, but not hard enough to hurt her. The defendant said the complainant then started hitting him, and he was blocking hits to defend himself.
Okay. Mr. Whittington, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with him or no?
A rip was attempted, but there is no contact yet with the complainant.
All right. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand?
Yes.
A protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can and probably will file additional cases against you, including a violation of protective order, which is one of the worst cases you can pick up. Just don't have any contact with her and everything will be fine. Do not pick up a new case. Do you understand?
Domestic violence cases main judge ka focus victim key safety hoda high. Protective order KO violate karna situation KO or Zayada serious bana sakta high.
Facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On December 18th, officer was dispatched to a driver asleep behind the wheel at 1219 Shepherd Drive. Upon arrival, officer observed a red van with the ignition on and running in a parked position in the middle of the roadway, sitting in front of the railroad tracks. Officer woke up the defendant and observed slurred speech and red glassy eyes. Defendant stated he had left a Christmas party at Club K9 and had consumed multiple Michelob beers. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 2 out of 4 one-leg stand. DIC was read, defendant consented to breath, 0.127 and 0.127, no criminal history.
Got it. Do you see if he has a valid Texas driver license? Do you
I
mind?
can run it now, Judge.
Please. Mr. Miller, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. Do you understand?
Yeah.
You have a lawyer. Because you have one, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel. If he comes back and tells me he can't get a hold of you because you're playing games, you're ducking and dodging phone calls, I will issue a warrant for your arrest.
And license is valid, Judge.
As long as you have a valid license and liability insurance in your name, you may continue to drive, but just be careful. If it does get suspended or if you don't have insurance, you're not allowed to drive.
Yes.
We good?
Railroad tracks के सामने गाड़ी चलते हुए ऐसो या ना सिर्फ dangerous नहीं, यान लेवा बेही हो सकता ते हा.
Judge defendant KO X second chance to raha high.
Yeah, really.
Is that here?
He's here, yes.
Adams?
Come on up.
How you doing?
Hi. Hi, Joe.
Hi, Judge. Nice to see you.
Merry Christmas, sir.
Merry Christmas to you, Your Honor.
What are you doing with your client?
Yes, sir. I did talk to him about the most recent offer that came in this morning. And the VA's not here, so I can't really respond back to her on some evidence. So we were going to go on.
Judge, she emailed me this morning. She's looked at the mitigation packet that defense sent, and she emailed me this morning telling me what her offer is. So everything that I relayed to her is her latest update.
What is the offer?
It's a 9-month deferred, Judge.
Yeah, and Your Honor, one of the things is just from reviewing this, it doesn't appear that the mitigation made it clear enough, or they didn't take very seriously the statement that the house that the complainant and her mother's living in right now is owned by my client. He's the owner of that house, and they are living there because he's allowing them to live there. Now, he's charged them rent before, but he has not moved to evict them. He wants this process to end, but somehow from the notes that they were reading.
What's your client's name? What is your...
Udlow.
Huddle.
Udlow. Hello, HPG, hello, government.
Yeah.
And,
The problem is that it's really old.
Your Honor, and I discussed that with them, and, so they're willing to keep, he wanted to talk to Mr. Garza directly. I've been back there calling for the last 30 minutes, if not longer, trying to
I
reach
mean,
him.
what we can do is I can give you till Monday, but it's plea or trial on that day.
Yes, sir.
You know,
That'll be-
Mr. Hudlow, come up.
And Judge, the state's offer is gonna stand. I mean,
Come around
Morgan,
this way, sir. All right. Good morning, Mr. Hudlow.
Morning. Merry Christmas.
You got to understand reasonable minds can differ. Just because you want something a certain way doesn't mean that it's going to happen. In life, it goes like that in every aspect. You know, when you're buying a car, when you're buying a house, whatever it may be. You know, he can't control the offers as they're going to give. He can only tell them merely what, you know, he is given a certain set of facts and he has to work with those facts. Sometimes they're good facts, sometimes they're not so very good, but it is what it is. Now, our case is old. It's 210 days old, and we set cases for trial at 180 days, and I have no idea how this got to be as old as it is now, but it's time to make a decision. Now, your case, they have offered you a 9-month deferred, which is a type of probation that if you successfully complete, you do not end up with a conviction on your record. You can't tell people it was dismissed because it's not dismissed. It's merely a probation that you took. If you complete successfully, you don't end up with a conviction, right? But that's the offer that they've made for you, and it appears as what the state has said, that it's going to stand. Look,
You're happy with that, Your Honor? Oh, I'm sorry.
you don't have to make a decision today. If you want to make a decision today and you want to be done with it today, we can do that. But I can give you one final setting to Monday if there's other people that you want to talk to. It's up to you, but it's time to put this baby to bed once and for all. So I will give you the opportunity now to talk to Joe to see if that's something that you want to accept now. If you need a little bit more time, I can give you until Monday. But at that point, you must either accept the plea bargain agreement or I'm going to set your case for trial because it's just too old.
I haven't had a chance to talk to Eric. Can we set it for Monday?
Okay?
I'm not saying that, you know.
No, look,
Actually, I would go
you
with-
don't have to say anything. I'm happy to do that, but you get no more resets after that day. So if you're unable to get a hold of him or whatnot, I don't care. You need to be diligent in getting together with Eric to figure out what you guys want to do with the game plan. Take a look at all the evidence, and then you make an informed decision at that point. But there's just no more time after that. All right?
Yes, sir. Yes, sir.
And I'm sure that Joe can try to get you know, help you get with Mr. Garza. Okay?
I don't know with his vacation schedule, you know, I don't want to put anybody out, but that's kind of how I think we ended up here.
We have too much.
Thank you, sir.
All right, guys.
His final clip, main judge Safkar Dita Hai Kudalays Hamesha Nahi Chel Sakt. Of defendant KO decision Lena Hai Haga. Deal accept carry a trial ka risk lu.